I guess the first thing I want to do is quote some of you in my courtroom when you said, well, we feel real sorry for this person, but it wasn't our fault. I am a trustee in 5 trusts, and I'm telling you that it isn't our fault. We are willing, and almost all of the trusts that I know of, to obey any lawful order of any court with jurisdiction. So if they say, okay, produce this stuff, we'll produce the stuff. So I'm not sure what the fuss is about in that regard. But I was going to...
Are there any mechanisms that you've thought of to accommodate the concerns about trying to account for the bankruptcy trust payments in connection with the claims in the tort system? Judge Alisi, Judge McBride, I'd be happy to hear your stories about that.
You know, at the risk of never being invited to one of these again, I will sacrifice sagacity for truth. The answer is, despite the amount of money that apparently is out there and the pressure from, advocates for the defense to get the principle of one injury deserves only a single recovery managed somehow, this plays about as much role in the settlement and disposition of asbestos claims in San Francisco. And I will say parenthetically, we have 70% of all claims in this great state, and we get 500 filings each year, brand new. It plays about as much a role as Tim Lincecum's ERA. It's just not something. It's my cousin. It's just not ripened by the dialectic yet. The lawyers are not demanding it. The court's not in a position to do anything about it if it's not teed up. Elliott's, I think, an idealist as well as a pragmatist, and when he says that the court has an interest in making sure this works. We may have an abstract interest in it. We may have an overall do good and make sure that everyone's treated fairly who comes before us, but we certainly don't have any practical ability to make it happen. In 2006, the First District published a case called Volkswagen of America versus somebody, and it was written by Stu Pollack, who used to be me. He used to be the guy who had all the asbestos cases. And he attempted to craft a rule about how our courts in the First District would deal with claims made in terms of discovery. In other words, if Bobby the plaintiff said one thing to a trust, then he ought to be held to it at trial. That case has never been used, to my knowledge. It just does not come up. I talked to the settlement judge who does all of the settlements for us. He's Jim Robertson. Those of you who dealt with him, he and Sisyphus are related. And he was stunned at the amount of information I gave him. He said, they come in and make some noises about the trust once in a while, but I settle the cases and they go away and nobody makes any noise about it.
I feel very much like Judge McBride does. I've had requests during trials for claims. I have directed that plaintiff's counsel provide a list of those claims made for bankruptcy trusts. That's as much as I've allowed during the course of a trial. I tend to agree with Rob Gordon. I think that if you want the information, you get it through discovery. I still think that's the way to go until somebody up above tells us there's a better way to do it. And my approach has been that in the event it should come up post-trial, in other words, in the event that a claim has been paid and there's been a percentage found against that particular bankrupt entity, that I would consider it as a collateral source offset against the verdict. Haven't figured out how I do that yet, but that was my thinking as how I would approach it.